know it's a cliche, but a year ago, if you would have told me, you know, there's no way I would have believed you.
Oh, good one.
Good one, very nice.
Oh, actually, you gave me too much.
So, Martin, how was your first day?
Great. Yeah, a little bit daunting, but it's fine. Just give me a couple of weeks to get up to speed.
No time for that, I'm afraid. Before Neil left, he was working on a major tender submission, and I need you to take it over.
Okay. Great. Sounds exciting.
It will be, if we win it.
Well, if it isn't Fiona Ralston.
Gordon, nice to see you. Gordon Hayes, Martin Tully.
Martin, hi.
Ah, Neil's replacement.
Yeah.
Oh, you got his car too.
Yeah.
Shame he didn't get his wife. No, seriously, it was a great loss. You know, he knew his way around. He's a good man, Neil.
You make it sound like he's dead.
You leave this industry, mate, you might as well be.
Gordon works for Cartwall.
Oh, come on now. Cartwall works for me. Right, look, I've got to keep going, Fee. I'll get some stuff over to you in the morning. Nice to meet you. Look forward to doing business with you.
Cartwell, as in...
As in the competition. Nature of the industry, Martin. Eventually you get to know everyone. See you Monday.
What you just saw is the beginning of The Marker, a short film produced by the ACCC to let businesses know that bid rigging is insidious and a crime. We'll return to The Marker later in this clinic. My name's Marcus Betsy and I'm the Executive General Manager of the ACCC's Specialist Advice and Services Division. I, along with my three colleagues, will be discussing a number of bid rigging related topics, including questions submitted by colleagues from ASEAN. Joining us today from Malaysia is Iskandar Ismail, Chief Executive Officer of the Malaysia Competition Commission, the MyCC. Before he was appointed as CEO of MyCC in October of 2018, he was the Director of the Investigation and Enforcement Division of MyCC. Prior to joining MyCC, he was one of the prosecutors for the United Nations International Criminal Tribunal for Rwanda in Tanzania for 8 years. Very warm welcome to you, Iskandar.
Hi, Marcus. Thank you for having me.
Thank you very much for joining us. Joining us from Singapore is Winnie Ching, Senior Director of Legal at the Competition and Consumer Commission of Singapore. Winnie's responsible for reviewing the decisions of the CCCS, supervising CCCS competition investigations, assessing mergers and providing advice on legal and policy matters. Not too much to do, Winnie. Welcome.
Thanks, Marcus, and great to be here.
Thanks for taking some time out from your busy schedule. Finally, joining us from across the Tasman Sea is Grant Chamberlain. Grant's been with the Cartels team at the New Zealand Commerce Commission for over 15 years, and he's the Cartels Manager. He's overseen the development of the NZCC immunity program, which he runs there, and he's overseen recent changes to a criminal cartel enforcement regime. Grant's worked with a number of agencies on developing their leniency programs over the years, and before joining the NZCC, Grant was a partner in a London law firm involved in defending antitrust investigations and proceedings. So he's a poacher turned gamekeeper. Thanks so much, Grant.
Thanks, Marcus. Great to be here as ever.
This very experienced, very knowledgeable panel is going to discuss the challenges of investigating and detecting bid rigging. Before we start the conversation, however, let's watch a little more of The Marker. This short film follows the story of Martin Tully, who finds himself in too deep with his competitors. Let's take a look at the situation Martin finds himself in.
It's been going on so long now that it's just the way things are done. They stick to the south and east, and we're north and west. We don't cross territories, and it's the same for the smaller guys.
When they keep their heads down, we don't step on them. Right, the last thing we want is a price war. No one wins a war.
The tenders get rotated around. You just fill them in as you're told. And if someone new starts up that doesn't want to play ball, then we just
Price them out. Now, these guys out west, I need you to get them on side.
The workers keep their jobs, the clients think they're getting a good deal, and we make our budgets. And no one says anything because it works.
Look, everybody needs to understand that this is how things operate.
We can see Martin has found himself in the middle of a cartel. The way the conduct is described, there's some market sharing and some bid rigging. This sort of conduct can also appear alongside corruption. Sadly, it's not uncommon for bid rigging conduct and corruption to occur hand in hand with each other. How should agencies proceed when there appear to be elements of corruption alongside bid rigging conduct? Let's turn to our panel. Iskander, perhaps you can lead off the discussion.
Yes, thank you, Marcus. Yes, bid rigging is a very hot topic right now in Malaysia. As you know, procurement activities has its own shortcomings and challenges. Leakages in government procurement especially is an open secret. Study shows that many governments in the world are losing around 30 to 40% of their money budgeted for their procurement. It's no exception for Malaysia. Yeah, there are many reasons leading to that situation. One is weaknesses in the procurement system. The second one, the government circulars, they are not updated. They are being interpreted by inexperienced officers. And fraud and cheating can take place also. Abuse of powers, including corruptions, are there. And last but not least, bid rigging. Yeah, but bid rigging is a new theme in government procurement discussion. Many government officials in Malaysia, they are not familiar with bid rigging. They feel that the first four factors are well known to cause these leakages in government procurement, but we think not. Yeah, so we have been advocating on bid rigging to many stakeholders, especially government officials, since 2012. Yeah, we have carried out, I think, more than 50 advocacy programs just for the government officers. We even have a leniency regime, to provide another resolution, especially for the industry players. Yeah, complaints have increased. Yes, that's a good sign. But we haven't seen the effectiveness of our leniency regime. I will talk more about leniency regime after this. And we found that they are more interested in fighting corruption. So what we did is that we turned our focus simultaneously to corruption factors in government procurement, because it seems that they are more open to open the door for us when we include corruption factors in our investigation. So we know that bid rigging activities can be instituted by corrupt activities such as passing of sensitive information. Basically, the agreement between bidders, usually bidders will somehow give a compensation, illegal compensation to other bidders so that they will suppress their bid and whatnot. Yeah. So we've been talking to our anti-corruption agencies. We call them Malaysia Anti-Corruption Commission, MyCC. So recently, they have made a policy to fight these issues in leakages in government procurement. So somehow we tag along. We went to them and we talked to them, and then they agreed to work together. You see, so our focus is that MyCC will go against the bid riggers, the cartel members, okay, in terms of them rigging the bid, the tender. But for them, they will focus on the receiver and giver of the money or the bribery. Yeah. So recently we worked in one case. It involved this big cartel group consisted of more than 100 companies. So they've been monopolizing these contracts within certain ministries in Malaysia. So they went in first, and then after they raided the cartel members, and then we went in and worked with them. Yeah, they found it is very challenging because they had to go through all the documents. Tender documents, they comes into volumes. Yeah, especially when it involve more than 100 companies. Yeah, it's not easy. So basically what we have done is that we are giving the government a more rounded resolution to these leakages. Yeah, we go against the companies who are the bid riggers. Okay, they will go against individual who help these cartel members to somehow manipulate all these tenders. Yeah, so there will be two prong action at the same time. It doesn't stop there. We can also take action, other action, administrative action, such as blacklisting them. Yeah, and then we can and MyCC, our anti-corruption agencies. What's more interesting is that they can freeze the money of the cartel members. They are facing difficulty right now because under Anti-Money Laundering Act, any corrupt money obtained from corrupt activities can be frozen by the anti-corruption agencies. So you see, it boils down to the money. He received wide coverage in the media, and we are happy for that. Yeah, it seems that everybody now is on our side, including the government side. Yeah.
Iskander, that sounds like very impressive. 100-party cartel. I think we'd worry if we found that in New Zealand. Working with corruption agencies sounds a great initiative. I had a couple of questions. One, what are the challenges that you face when you're working with the MyCC? And separately, how does it work in terms of, you mentioned your leniency program. How does that work with the MyCC? And do they have a leniency program, and how do you work that together?
Okay. This cooperation is still new. It hasn't been tested. Somehow it hasn't been tested to the full extent where we can find balance in our action. But one of the challenges that I can say now is that our cases, we just have to prove it's not criminal in nature. MyCC cases are not criminal in nature. It's more on civil prosecution. So the standard of proof is balance of probabilities. Yeah, but for them, they have to bring their case to the court. So their standard of proof is beyond reasonable doubt. That's one challenge. Yeah. The second challenge is that we are going to use the same evidence. Yeah. So we have to be careful in this because we need to ensure the chain of evidence is intact. Yeah, it's very important in criminal cases. The chain of evidence is taken care of. Yeah, so that the defense won't use that to their advantage. And of course we have leniency regime. Okay, and then they have somehow they have the discretionary to be lenient with the person that they are investigating. Usually, some of the cases that we have noticed is that what they do is that they will charge 2%, let's say 2% in one case, and then suddenly one person they will approach the anti-corruption agency and they say, okay, I will become your prosecution witness, your crown witness, but please drop my case. Yeah, so that's what happened. Yeah. So for that we have intimated to them that we need balance here because if you want to stop the leakages in government procurement, you have to target the giver of the bribe. It's very important. The giver is part of the cartel members. They're the one who control and monopolize and manipulated the tenders of the government. It just so happened that they have made friends because they've been doing it for many years. Yeah, we came into the picture in 2012 grant. Yeah, so they've been doing that since in 1990s and early 2000, and then that's why you stumble upon more than 100 companies getting involved in one particular tender, forming a cartel, and then happily won, you know, the tender. You see, so what we told them is that don't if we investigate together, please don't give any leniency to the giver. It's very important because we are targeting the cartel members, and amongst them are the giver of the bribe.
It definitely sounds like a win-win for everyone. That sounds like a great initiative.
The thing that really resonates for me is the value that you can get from collaboration within government. And particularly with the central agencies like a Department of Finance or audit officers, and we've certainly tried doing that over the years and had some success. Grant, did you have anything you wanted to add to Iskandar's comments on that issue of working with corruption agencies?
I think what Iskander has described sounds excellent. It sounds like you've really put some hard yards in to make it pay off. It's hearing lots of agencies around the world following the money trail is absolutely critical, and I thought that was a really interesting point. We've worked with agencies in New Zealand in relation to trying to understand that. I think it's a real bonus what you said about them being able to freeze accounts. I think that will, if you're trying to stop people from being able to pay bribes and be able to essentially set up bid rigging conspiracies where one half is sort it out with your competitors, but you also need to sort out paying the official to make sure they don't make a mistake. Being able to freeze the account sounds like a wonderful thing that they can do that will stop people in their tracks. So that's definitely something I'll take away to talk to the anti-corruption agencies here. We have something called Proceeds of Crimes Act over here, but it definitely sounds like a very interesting point you've got there in Malaysia to be able to do that, to get the MyCC to freeze accounts. That sounds brilliant.
And Winnie, any reflections from you?
I was just going to ask about the blacklisting that you mentioned, Iskander. In relation to the blacklisting, is it just the company that engaged in the bid rigging conduct, or does it extend to their related companies? Is the blacklisting for private tenders, government tenders, and is the blacklisting for a certain period of time, or does it extend indefinitely? All of these questions sort of filtered through my head as you were talking about it.
Yeah. So so far what we have done is that when we investigating the companies, the cartel members, we will form a database, and then we will list all the companies that are being investigated, are being suspected of, indulging in this cartel. So we will give to the certain ministries for them to refer. Yeah. So it's up to them. Yeah. Usually, what they do is that once they see the list, and then if one of the companies is one of the bidders in the current tender, then they will put them aside straight away. I think that is somehow effective in some ways, but putting them in blacklisting forever or in eternity, we haven't come across to that yet, but we are thinking of ways of how to use that list effectively. Yeah, because for example, I give you an example. Police database. You see, they have database of people who are being arrested, who are being charged, and whatnot. You see, so at least we have some reference, some history of the bidders. I think that would be good, and then it's up to them if they are given the discretionary power. I mean, it's up to the agencies on how to use that information to their advantage.
Great, thank you. Iskandar, one of the things that we're very keen to do today is to address some of the topics that have been raised by our colleagues within ASEAN. I'd be really interested to hear from you as to what you think we should be addressing in the panel.
Oh yes, you see, one of the hottest topic right now, beside bid rigging, is digital market. Yeah, recently Malaysia has came out with Malaysia Digital Economy Blueprint, and MyCC is entrusted to amend our law so that it can cater the issues under digital markets. So we are trying to learn on how to go about it. I mean, it is a very complicated and a very technical area. Yeah, recently we need Singapore, Indonesia, Philippines, we somehow gang up, coincidentally, yeah, against Grab. Yeah, so we have issued, decisions. 4 countries in ASEAN have issued decision against Grab, and we found that multi-sided markets in digital markets are quite, I can say it's so challenging for us to, to dwell into it, to understand it, and whatnot. But I heard recently, cartel can take place in digital markets. So this is another development that I would like to hear from you guys, any of you guys.
Probably Iskandar, from the New Zealand side, like many other agencies that we've already touched on, what's going on over there with the MyCC, we've been focusing on digital markets, and we do have some experience with bid rigging in digital markets. So that's probably a topic we can cover off if you'd like.
Yes, please go on, Grant. It's going to be very interesting, and we would like to learn more from you.
So there's probably 2 main areas I'll try to cover off, and if I don't do it well, please stop me and I'll try and explain it again. So we really, probably over the last 5 years, have seen a far greater use of digital tools used in bid rigging. What I'll also touch on is how we've dealt with a buying conspiracy on a digital platform, which I thought would be quite interesting for people to hear. And then specifically a very recent example of bid rigging on a digital platform. And I'll touch on that as well if people are interested. But sort of the first topic, digital tools that are used in bid rigging. I thought, like many agencies, we've seen an increasing use of encrypted tools. WhatsApp, WeChat, etc., and even closed Facebook groups. We've seen them being far more used as a tool by cartelists or potential cartelists. But they bring their own issues. I think one of the big things in my experience of too many years in cartel enforcement is the means by which agreements are set out has definitely changed. Very rarely do you get the perfect document that sets out, here's the cartel agreement. We've increasingly seen that the key messages and the building blocks to fill up the puzzle of the agreement between the cartelists is often on these encrypted platforms, such as WhatsApp. Encrypted data does present its own problems. We've had some experience with dealing with those issues. I wouldn't say we're masters of it, and talking to our ACCC colleagues, our US colleagues, we're learning all the time around some of it. But I think the encryption issue is not going to go away, so we've learnt some different things that we've tried to approach it with. Now, for example, if you're doing search warrants, we very much target phones straight away. If we are going in to do a search on a premises, then targeting the phones absolutely should be the first thing, because if you can get hold of the phones, hopefully you'll be able to get to those encrypted messages very quickly. Getting them into flight mode is one of the quickest things that we've learnt. Secondly, when issuing notices or requesting information, we're increasingly starting to focus on asking the companies about what's their policy around using some of these messaging platforms in particular, because there are quite a lot of companies here in New Zealand that will allow you to use WhatsApp for business purposes, and actually understanding how they're using it is quite useful to understand whether individuals may have been messaging their competitors, etc., over those platforms. Sometimes businesses do actively encourage it, and so we often ask them questions in requests for information or when we issue statutory notices. What also interestingly, sometimes they actually back up on work phones or work devices some of those messages, so it's actually really useful to follow up with the companies, even if they aren't aware of what their employees have been up to actually ask them some questions around how things are stored and what knowledge they actually have. I suppose one of the things we've also learnt, sometimes it is just very difficult to get hold of them, so asking the telecom providers, the Vodafones of this world in particular, what messaging they're seeing passing over their platforms, passing over their networks is really important. Because even if you can't actually get to the messages, sometimes you can actually just see that there's communications going on, and also they're able to locate potentially whether people are in a local vicinity to where a meeting is taking place. And probably the last point I just make around being able to access is we've started to increasingly ask people to bring their phones to what we call compulsory interviews, just so that they have to actually present them to us and actually ask them to explain whether they have messages on those phones that would be relevant to the investigation. I would say we do have to be slightly careful, because when we do ask them to produce those phones, they are under compulsory interviews generally, so we can't use that information they provide at those interviews, similar to the ACCC against that individual. But it is a useful way of being able to actually get them to present their phones.
How times have changed, Grant, and look, both of us have been around for long enough to have seen how the technology has really changed the way people engage in cartel conduct, and one of the really good things for investigators is that so often they do record their agreements, their arrangements in social messaging applications, and often they think they're confidential. Often they think that they're not able to be viewed by government agencies, and of course, as you know, that's not always right, and we've certainly had some investigations where we've got some fantastically revealing material. I think if the marker was produced today, it would look very different. Martin would probably have less in-person meetings. He might do some Zoom meetings or Teams meetings, and he'd certainly have more encrypted messages that he was being involved in.
I agree with you completely, Marcus. People were often very relaxed with what they put on their different messaging platforms, thinking that they are not accessible when in fact they are, particularly if they back them up. One point I was going to mention, pricing comparison sites. We like them because it enables consumers to understand pricing around a whole range of goods and sometimes even services. But not only are they great for consumers, but they are a digital tool that we've seen on a few occasions be used by cartelists to enforce and check pricing is being maintained. So here in New Zealand we have Price Me and Price Spy. Price is obviously the key bit given by the titles of those particular websites, but it is really interesting that we have seen those come up. They're great for consumers, but I would probably say they're definitely a digital tool that can be abused by cartelists. So we are very much alive to that. One of the other things I was going to mention as well, just around digital tools being used for bid rigging, is you do have to be really careful in terms of accessing some social media sites. In particular, we have particular guidance around what's acceptable or appropriate going onto social media platforms. And one of the real difficulties is I was talking to a number of agencies a few weeks ago, and Facebook has an algorithm that checks for fake IDs, etc., and it's constantly evolving. And one of the things is a number of agencies find it very difficult to be able to go on and do covert surveillance, for want of a better phrase, on there. Now, it can be completely legal, but you do have to be very careful. Technically, a fake profile is a breach of Facebook's terms and conditions, and so it's just something that we've noted that's definitely worthwhile if you're using Facebook, etc., digital ways of going in and checking on communications. Just be very aware that that can cause certain problems with sites such as Facebook and other social media platforms. But linked to that, very interestingly, and hopefully the group finds it interesting, we had a bid rigging conspiracy in our largest city, Auckland, and that was a bid rigging conspiracy over a Facebook group that were bid rigging on certain value residential properties. Essentially, in that case, it's in the public domain, so I can talk about it. It was a case where essentially the Facebook group took pictures of a particular property as soon as it came to market, and they then would flag whether they were interested in the property, and then they'd have a place in the queue, and no one was allowed to bid until they had decided whether they wanted to bid. So there was, it wasn't the largest group. It definitely wasn't 100 companies, like Iskandar's mentioned. It was probably close to about 300 or 400 individuals, but it was a very interesting case because it was a buyer side cartel, which is slightly more unusual for us here in New Zealand, and we did have slightly different ways of approaching what would be the harm there, because you're not seeing prices to consumers. It's a slightly different way of thinking about it. It's not the traditional overcharge sort of analysis we do when we look at cartels. So I thought that was, again, just a useful thing to say, that sometimes with these sort of conspiracies on Facebook, just have to be very careful how you're using those sort of tools.
Winnie, did you have any perspective on these issues?
I was going to say, I found it really helpful, Grant, just to hear about the techniques that you use in relation to interviewing, gathering the evidence, as well as the case that you mentioned about the buyer side cartel, because they're certainly rare in our jurisdiction as well. You mentioned, though, bid rigging on platforms, and as Iskander mentioned, this is an area that ASEAN's very interested in, and we in Singapore have just completed a market study related to digital platforms. So if you've got more examples to share, that would be great to hear.
Sure. So it is a very recent investigation we completed. We're taking enforcement action now. So I might anonymise some of the details, but hopefully everyone can understand what it was about. So it was essentially a series of agreements over a number of years in relation to bid rigging on what's called Google Adwords. Now, Google Adwords, essentially you get, for want of a better phrase, all your organic results, and then at the top, they're above a ribbon on Google search results. If you type in wanting to buy, for example, a laptop or something like that, certain companies will bid to be able to be above the ribbon, because people, particularly when they're looking at devices like an iPad or a phone, I shouldn't just say iPhone because it makes it sound like I'm obsessed with Apple, but when they look on those devices, they'll see things above the ribbon. That's really important in terms of people actually don't tend to scroll through tons of lists. So Google auction these AdWords across different areas. They do auctions pretty much every minute of the day they run for these AdWords, because it's a global platform. Even if they're words that are peculiar to your jurisdiction, they tend to run them continuously. The one thing I would say is that when you're dealing with such a sort of conspiracy or agreements around bidding on Google AdWords. When we started on that particular investigation, it was brought to our attention through a complaint, and as much as we knew some information around how Google AdWords works, we didn't actually know all the details around it, because there is a Google algorithm that prices for Google AdWords. Now, some of the material is public, some of it obviously is a closely guarded intellectual property right they've got around this algorithm. So it was quite a challenging part of that investigation, because obviously we need to be able to prove that there has been an effect on price. So this is a bid rigging conspiracy, and under our old law up until 2017 we had to prove an effect on price, not after that. So these agreements covering a longer period of time, it was really important that we could see an effect on price. So we needed to understand how Google were calculating what the relevant price was. But I would say one of the things that we did learn was there is a lot of material out there. It's not always available on every single website, but we found it extremely helpful talking to colleagues at the ACCC and the DOJ and the FTC and the Canadian Competition Bureau around information they held about how Google AdWords works. That was really important for us to be able to understand what could be the pricing impact. I would say that the bid rigging did last over a number of years and was very specific AdWords, which they knew that people would be interested in bidding against. I will say, in fairness, it wasn't things like Coca-Cola. It was words that was quite related to their business operations in a specific field. There was a number of jurisdictional issues that did come up, because we cannot compel information from Google in the US or its headquarters in Ireland. I can never remember which way round it is. We can't compel that information from them. If it was now we were doing the investigation criminally since April this year, we could make an MLAT request, but it was under a civil regime, so we were limited in some respects. What I would say though, we needed the data from Google to be able to understand some of that pricing information. We could get some of it through different parties, we could get that. But it was important, and I would say whenever you're dealing with a digital platform that's not in your jurisdiction, you do carefully need to think up front, how will I get that information? What are the different tools available for me to try and get that relevant information about how the pricing works on that digital platform? We were fortunate enough that we had a number of parties assisting us who were involved in the conduct, and they were able to request information themselves as participants in Google AdWords auctions, which we found was really helpful. They can get information a lot easier than a regulator, and particularly if you're the size of the NZCC, trying to get hold of Google, they're not necessarily going to answer your call as quickly as they might the DOJ or the FTC. I would say though that one of the things that's really interesting about these sort of platforms such as Amazon and Google, one of the things we've observed is through something like Google AdWords, they produce an awful lot of information that's to help the people bidding on the particular auctions. But that, again, a little bit like our pricing comparison websites, they were actually used in this instance by the bid riggers to check that the people that weren't supposed to bid weren't bidding, and they were getting reports come through that could indicate that material to them. Now, that doesn't mean that Google shouldn't put out that information. It's really important that people understand what's going on with auctions, but it was definitely being used to check that people were obeying the agreement, and it was also used, we found quite interestingly, for people outside of the agreement that started bidding, different businesses, they would then get a request to form an agreement with a particular party once it was clear, once the party was getting the data from Google that indicated they were bidding. So again, similar to what I said about what we call Price Spy and Price Me, really important that you're aware of those sort of tools out there. We went through quite a journey of learning on that case, but it was a really interesting one to see a bid rigging matter on a digital platform. There was a lot more we learnt probably in that investigation than in a number of other sort of cartels of localised services over the last few years.
Great, thanks for that. Winnie, does that resonate with you, that experience with the digital platforms?
I think it's one of those areas where there is a learning curve associated with it, and I think, Grant, we may be tapping on your experience on that in future.
Great, thank you. Thanks very much. Well, let's check in with our fictional character, Martin, and see how he reacts when it finally dawns on him that what he's doing might not be legal.
So what do you reckon?
What do I reckon? Well, let's see. You've got a bit of price fixing, some government tender rigging, and dividing up the territories. It sounds like you're running a cartel.
Jesus.
Mate, what I reckon is that you've got to get out.
I can't. No one leaves. No one ever leaves.
You need help. You need to talk to someone who knows about this stuff.
Yeah. Who?
I don't know.
The marker has an interesting portrayal of the journey someone can go through when discovering they're in a cartel. It does a great job of contrasting how complex their decision to come clean is, their family pressures, from their family pressures to financial incentives. Do you think this is a realistic portrayal, Winnie, of what someone might go through and how important a leniency program is, not just for the agencies to gather information, but also for individuals and companies who find themselves in these situations?
Thanks for the question, Marcus. Let me start with how important and useful leniency is from an agency perspective, and then also touch on the perspective of the business. And then let me first start, though, with what leniency is for an agency. I mean, for us, it's a policy whereby you offer a discount on penalties, financial penalties. In other jurisdictions, it can actually mean immunity from criminal prosecutions. So it can depend. It's in return for information about the cartel, possibly admission about what has happened, on conduct such as price fixing, market sharing, bid rigging, and restricting output. In Singapore, which operates under an administrative system, CCS's leniency policy offers immunity for the first person that comes forward. But then it offers immunity also a considerable discount on penalties if we're already investigating cartel conduct. And then if you come in after the first person, you can also allow yourself of a leniency discount of up to 50%. That depends, though, on the time that you come in, the information that you offer, and what we have already in our possession. From an agency perspective, the real benefit is it's a means of being aware of cartel conduct that you wouldn't otherwise know. Cartels can be quite secretive in their operation. You saw the marker video, and that is an illustration of that. And sometimes there's none or very little documentary evidence. If there is contemporaneous evidence, it's often sparse, and so having somebody who comes in who can tell that story can really add to the evidence that you have as an agency. They can often tell you who was involved, the dates, where the conduct and the meetings took place, and the nature of what was actually agreed, which from that sparse documentation you're sort of piecing together. It has to, though, be taken in context. So you can obviously have leniency applicants that may be more forthcoming and over contextualise the conduct in order to try and fit within the leniency policy of the agency. So it is quite important to take it with that in mind. I think I'd also add from an agency's perspective, it's really effective tool. So in preparing for this today, I did some numbers checking, and I think in relation to about 50% of our infringement decisions, they have involved leniency.
That's a fantastic number and a really interesting perspective, Winnie. And just to compare or make a contrast, in Australia, around 85% of our cases have involved immunity at some point. So that's 85% over the last 10 years have involved some form of immunity. Now, that doesn't mean they've necessarily been instigated by an immunity application, but there's been immunity through the process.
Thanks, Marcus. That's a really interesting statistic and does demonstrate how important leniency can be as a tool for an agency to use. I said I would turn to the business perspective, and let me do so now. From a business perspective, it's a chance to avoid fairly hefty financial penalties. And for the individuals involved, it can mean that they can avoid jail as a possible sentence. So there are real incentives for businesses to come forward. In Singapore, we operate under a civil regime, and so as a result, individuals can't face that sanction. But in other jurisdictions, it really is quite a lever that can be utilised. That said, for businesses and individuals, sometimes it's not about the financial penalties that they face. It's actually about the reputation and those consequences associated with the detriment to their image. By enjoying the benefit of immunity, that reputational repercussions can actually be lessened. But I don't think it's an easy decision for businesses. I can think of a number of instances where I've received a call and the business or the law firm on the line has just asked, would it be available? We call it a feeler call. And it's obvious that prior to calling us, they put in a lot of thought as to whether in fact they should call us. And they don't necessarily apply for leniency straight away. So then they'll call back after more discussion with their board or their management and then make the application. And I think that the reason for that is because there are a number of implications for the business. And they need to think fairly carefully about those implications in order to make that call that they want to come in for leniency. How it can affect their relationships with their suppliers, how it can affect their relationship with their customers. That said, I've also had applications where they've just been alerted to the conduct, realising it, they've come in straight away because they want to make sure that they demonstrate that they're good corporate citizens, and they want to minimise the impact straight away. In those situations, we do walk them through leniency and what it can entail. But it just shows that there is this difference that can occur for businesses and what they want to think about before they come in. But it is a race to the door, and we have had applications that have been less than 24 hours apart. So it is something that businesses, once they become aware of, do want to think about coming in as soon as possible.
Yeah, thanks, Winnie. And I've certainly had some of those phone calls myself. And we certainly encourage people to just pick up the phone and seek a marker as soon as they can, because a few hours delay can be the difference between having your client or having your business on the end of a very very, very expensive court case and potentially in our system, criminal sanctions.
I completely agree, Marcus. It really is a race. And I should also mention here that CCS has a reward or whistleblower scheme. And so you can have individuals that can also, if you like, race to give us information about a cartel. And under these schemes, and it is complementary to the leniency policy, under these schemes, an individual can stand to benefit by providing useful information that may lead to an infringement decision. Obviously, confidentiality is a key component of this, but it does demonstrate how important it is that if you do receive information, that you can avail yourself of quite decent benefits if you're who is looking at such conduct, which obviously Martin did in the marker. Which actually leads me to the other question that you asked, which was how realistic the marker is as a portrayal of what can happen. And I think it is quite realistic in many senses. It's very real that bid rigging occurs, price fixing, market sharing, as we saw in the clip. I think also that the emotions that the characters go through is something also that is experienced by cartelists. The relief that Martin feels when he, if you like, comes forward and sees that he himself has availed himself of immunity from the actions of. I think also where the cartelists try to justify their conduct by saying it'd be helpful for the industry, I think that's also something that cartelists can do. But what they miss out on is really that detriment that occurs to their customers or suppliers or whoever is affected by the conduct, which is something that often doesn't cross their minds, but is something that is quite harmful to those groups of people.
I have one question.
Yeah.
We are in the midst of amending our law. One of the main sections we are looking at is improving our leniency regime. If you have one advice for MyCC, what would you give to us? Because we have issues in getting the somehow the response, the positive response through applications by parties. We haven't got, we got few applications so far, for the past 10 years.
So when we began our leniency policy, in the first 5 years, I think we only got less than 5 applications. Then it really took off after that. And I think it was about the transparency with which we operated the leniency regime. And it was also about how inclusive we were about how you could get leniency. And we continue to operate that policy today. So if conduct is borderline cartel conduct, we will include it within the leniency tool such that companies or businesses can avail themselves of leniency. And we step through it so that it's quite clear that there are benefits. So, for example, where we send out a notice, where we ask for information from business, if you're under our leniency policy, you often get more leeway from us than if you are sent a notice from us. And it's all about encouraging leniency applicants to come forward and the treatment that they get as a leniency applicant. So I think my one tip would be continue advocating for it, and the numbers will come. The other, if you like, spearheading part of our leniency policy is that often when we go in for a dawn raid, we do let the cartel members know when we're on that dawn raid that our leniency policy is available. And we do get a lot of applicants from that process, because often businesses may not be aware that the policy exists. And stepping them through it during that raid can often be quite helpful to encourage businesses to come forward.
Oh, okay. Thank you so much, Winnie.
Thanks, Iskander.
And Iskander, I might add to Winnie's comment by saying that when we first had our cartel cooperation and leniency policy in place, we had hardly any applications for a long time, more than 5 years, maybe 1 or 2 applications. We're now on, I think, version 4 or version 5 of our policy. And each time we've made slight changes to it to improve the way it works and really to respond to feedback that we got from the legal community mainly, although sometimes general counsel in some firms that had experience dealing with us through the immunity policy, and we gave them, we focused on giving them more confidence in the way we administered the policy so that they could trust that they were getting a benefit. And I think that's the really important thing. It's got to be more beneficial for people to come in through the leniency policy than to not come in. They must perceive that they face a much more substantial risk in not coming in through the leniency policy.
Working with lots of different jurisdictions about revisions to leniency and why it may not have worked for their jurisdiction, there's a few things that I completely agree with Marcus and Winnie on. I do think transparency is absolutely critical, and it's got to be a bright line test that if they qualify, it's not discretionary, you get it. I think one of the other things Marcus said is I do think it's really important with the law firms to really drum home the message that actually this is in your client's best interests. But I do think it's quite important when I've worked with different agencies, is there something that's blocking it within a cultural thing or something like that within the business community? Is it something they're not prepared to do because they don't want to be seen to be informing on their friends or something like that? So you have to make the balancing act. If you don't come in, the threat of detection must be very clear. The fear of actual detection. So you've got to have both sides of the program. You can't rely completely on leniency. You have to make sure you're doing cases yourself. But I do agree, it does take time for it to come through. But I think if there's a blockage that's stopping the leniency coming in, think about your other tools. Winnie's mentioned it. There's the whistleblower tool. Some of those are very cheap. I know the ACCC has one. We have one. They're really important. They're actually very useful for leads. I would say, though, when you're looking at a leniency program, sometimes people, particularly around cooperation, one of the things we've advised a number of I've advised a number of agencies to think about is would it be more palatable to think whether you could have 100% cooperation program? And what I mean by that is there something that people may not necessarily come forward straight away, but as Winnie says, when you do a raid or something like that, you leave the message, actually, this is in your interest to come forward and cooperate completely with us now. And maybe it's not under the label of leniency. I don't know whether you have a defined amount of discounts for people as they come in, but they generally, the agencies I've worked with, there's usually something that's blocking it, and once you cure that, then they start coming in. But it's just about identifying. And I think talking to the legal community, we're up to revision number 4 or 5 now. I think we might be one behind the ACCC. We usually follow the ACCC, so we might be one behind. But definitely think about that. Talk to the legal community and say, what is it that's not bringing forward those cases? Do it even anonymously, not through an anonymous whistleblower, but talk to the legal community and see if they're prepared to engage with you to give you the answers around that. What is it that we're not doing to get this for your clients? I think having that frank conversation is critical.
Yeah. Look, I couldn't agree more strongly. When we first put out our policy, our first version, it had a requirement in there that there'd be restitution paid to people who had been adversely affected by the cartel. and we didn't get any, or I think we only got one applicant under that policy. When we went around and asked people why they weren't coming in, that was the thing that was the blocker. That was the thing that, when you inserted it into the calculation that they were all making, meant that it just wasn't worth approaching us for leniency. So I think you're probably at exactly the same stage that we were, if that is of some hope to you. But it is just a matter of going and talking to the regulated community, and more importantly, their advisors, and just finding out what would give them more confidence. What are the things that are important to them in terms of making the policy more attractive to them.
Okay, I'll take that. I'll take note of that. We'll do the necessary, because one of the challenges that we found is that they always question us. What can you give us beside the discounts? How can you protect us, from other cartel members? Are you going to make sure that we're going to be more somehow free from the peer pressure, in the future? Because you see, sooner or later, in the decision, somehow people will get the drift that somebody has snitched against them, and then there will be some repercussion in any forms. You see, so that is what worried them. You see.
Yeah. Well, look, these have been some great points that have been raised, and thank you so much, Winnie and Grant and Iskander. Great points discussed here. I should say the HLC leniency program has been very, very important in detecting cartels. As Grant says, we've now got a whistleblower program. Once again, that's been evolving and improving over time. When we first had a whistleblower program, we had no way of contacting the whistleblower and speaking to the whistleblower. And so now we have this anonymous facility where we can communicate with them after they've raised an issue with us, and we find that that's much, much more productive and is leading to a lot of investigations. In the market, the HLC wanted to let businesses know how we might deal with an applicant should they come forward. And so in the next scene, we see what happens to Martin when he reaches out to the HLC.
So I found the website, and then I called.
Now, Martin, as we've discussed, only the first person who approaches the HCCC can claim immunity, no one else. And this is only the case where the person clearly isn't the leader of the cartel and hasn't coerced others to get involved. On that basis, and on the evidence that you've provided so far, I can confirm that an immunity marker is available to you. But to proceed, we are going to need your cooperation.
Yeah. I understand.
So, Iskander, what I was going to say was, I thought you raised a really interesting point about the blacklisting, which is why I asked the question earlier. And I wondered in my own mind whether one of the benefits potentially, if you are blacklisting businesses who engage in cartel conduct, if those businesses came forward and knew that by coming forward they wouldn't be blacklisted, I wondered if that was another benefit that they would receive versus just getting a discount on their financial penalties. Because often the financial penalties reflect, if you like, the past conduct. But if you're blacklisting people, it affects their future conduct. And by not being blacklisted and having that potential to win work in future when otherwise they wouldn't be because of the blacklisting, it may add that potential benefit, that extra kick, if you like, into the leniency policy that may not otherwise be available. So I did wonder, given that you're considering this program of yours, whether or not you would include or think about blacklisting, and indeed we may follow you in relation to how you proceed.
Yeah, but yeah, blacklisting I think is effective because usually the government wants experienced and established players to go into their tenders. They have certain reputation, so of course they can form a new company and then go for the future tenders, but it won't work elegantly for them anymore, you see. So no, it's just that yes, we have certain sections in our law on how to protect them from certain repercussion. But the thing is, we are not something like police or anti-corruption agency who has the facilities, to somehow protect them physically or maybe emotionally, Yeah. So that is, the angle that we are looking at also.
If it helps, Iskander, one of the things, people are always fearful of repercussions, but I think one of the things you have to explain with the leniency program, even if you're limited, the agency will do their best with what they've got to be able to protect you. And I think that sort of honest point is really important. So, for example, in Australia, they have protected disclosures. That's written into law. But for us, we have a section at the back of our leniency that says, what will we do to protect your confidentiality? Does that mean you're never going to have to give evidence in court? No, that you may well have to. But talking about what are the important things we can do to try and protect you, even the practical stuff of, we will try and use you as a lead, but we might not ever use you in court. Now, we may do, but we will try our best not to have to do that. I think they're the sort of things you should be saying and putting it in your policy, but also when you're out doing outreach, is actually say, well, what are the things we do to protect our leniency applicants? I completely agree. We aren't the police either in New Zealand. We can't protect people, put people in witness protection programs and those sort of things. But you've got to be able to sell a position that what can we do, and we will fight to the hilt to do that. We've defended court proceedings where someone tried to get hold of a leniency file and we fought it tooth and nail like it was the fight to the end of the earth. It's really important to do that sort of, protect them as much as you can. You can't insulate them completely, but also tell people the stuff that you'll do. Really put it down in clear in writing. What will we try and do to protect you? Because people do get comfort from that, knowing that they're not going to be hung out to dry at the first opportunity by the agency.
Thank you so much for the advice, Akran. Thank you so much, Winnie.
Marcus, I'd like to get your opinion on advocacy here. How important is it for competition agencies to reach out to government departments and businesses? I know that different jurisdictions have different powers and obligations. For example, the Indonesian Competition Commission can make official recommendations to other arms of government. In Singapore, we adopt a whole of government approach where we liaise with each other and try to come to a common approach by which we'll proceed. In the marker, I know that that's a form of advocacy for the ACCC. What is the range of advocacy undertaken by the ACCC, and who do you target your advocacy efforts to?
Thanks so much, Winnie. The ACCC isn't just an enforcement agency. We take enforcement and advocacy very seriously. It's all about achieving compliance within the markets that we are responsible for. We put considerable resources into these activities. So we've got an advocacy team and we've got a cartels branch that both engage very significantly in advocacy work. And they do outreach, they do education to increase awareness of bid rigging in the public procurement space. And this really is ongoing work that has to continue on a regular basis to ensure that the knowledge isn't lost. When I specifically think about our work in relation to bid rigging, there are a number of ways in which we interact with both government and private sector players. We regularly present to and assist government agencies, including in our states and territories, who engage in procurement and tenders. We proactively contact government departments that deal with tenders and give advice on proposed tender processes to minimise the risk of bid rigging conduct. One of the most important documents that we've created is a set of guidelines for procurement officers within government. The guidelines help procurement officers in drafting tender processes, and so we really begin at that stage of procurement frameworks, and we provide advice and tips on how to draft a tender process that discourages bid rigging conduct from occurring. So, for example, our guidelines contain some prepared contract provisions which help departments and organisations protect themselves against bid rigging. Just to illustrate that, we've got one suggested provision that requires people or businesses to give a warranty that they haven't engaged in bid rigging. This is important because in Australia it's an offence to lie to a government department, and this can also lead to damages able to be recovered by the government department in the event that they've lost money through the bid rigging activity. The provision forces businesses engaging in bid rigging to actively lie if they want to continue to engage in that activity. And it's another way to increase the risk that the business takes when it engages in bid rigging.
Marcus, we found that certain guidelines that we have in MyCC right now is quite helpful. Do you do any person-to-person training in terms of this situation?
Yeah, we do. An important part of our advocacy and education work is teaching procurement officers how they can actually detect bid rigging, and we do this in our guidance documents. Some of the things we encourage people to look for are different tenders completed using the same language, common mistakes such as spelling mistakes across multiple tenders, the sudden and unexplained withdrawal of a very competitive tender, the rotation of winning bids among competitors. And I had a great example of tenders submitted in a slightly unusual font, which got a procurement officer suspicious about the collusion that might have been going on between some of the participants. One of the great benefits of training these officers and developing relationships with them is that it has the effect of creating a network of public officials who can detect and advise the ACCC when they see any sign of bid rigging. It's a bit like having our own spy network out there looking for cartel conduct. Often the relationships are very informal, but I do have an example where the relationships become more formal. We did some outreach work in South Australia, and that led to the negotiation and signing of a memorandum of understanding with the state of South Australia on cooperation in consumer and competition matters. This might seem a bit strange, but in our political system, it's important that all levels of government are committed to combating anti-competitive conduct. And the MOU requires the South Australian government to provide the ACCC with relevant information if the South Australian government believes there might be cartel conduct. If we initiate contact, it requires the South Australians to provide us with all relevant information if the ACCC informs the government that we think there might be cartel conduct. And it means that we can interview and get statements from South Australian government employees and contractors if we need them. South Australian government tenderers are also encouraged to use the tender clauses that we have recommended will discourage bid rigging conduct. All the information I've discussed today is actually available on our website on a dedicated information page on cartel conduct and bid rigging, where members of the public can find the information that I've mentioned and other advice on bid rigging conduct.
Does the ACCC engage in any unusual advocacy, Marcus?
Yes, and I can leave you with a couple of non-traditional examples of advocacy. Some of my colleagues are currently working on a cartel screening project with ACCC staff developing a program that uses algorithmic programming to detect bid rigging conduct by screening tender applications. There's been liaison with international counterparts on this project, but if we get it fully functional, it will significantly change the way in which the ACCC and government departments screen for cartel bid rigging conduct. This has been one of the side effects of setting up a data analytics unit a few years ago. They're people who've got a really good understanding of how you unpack algorithms, how to make algorithms work in a way that helps us. And it's a much more sophisticated approach than perhaps 10 years ago when we first started hearing about cartel screening tools. Finally, everyone's seen another left field advocacy strategy the ACCC has used for bid rigging, the marker. When cartel conduct was criminalised in 2009, the ACCC looked at ways in which we could get the message out there. Part of that strategy involved the development of the marker. We engaged an up-and-coming film crew, and the result, we think, was a pretty professional, slick product that we're very proud of. It's been picked up outside of Australia, and I'm very proud to say it still gets quite a few followers on YouTube.
Good plug.
Thanks so much for watching Clip's Competition Clinic on bid rigging. I hope you found it insightful, interesting and educational. I'd really like to thank each of the wonderful panel, Winnie, Grant and Iskander, for sharing their experience and insights and questions. And I'd like to now draw the clinic to a close. Other competition clinics and resources from both the ACCC's CLIP and CAP programs can be found on the CLIP Academy website. Please check them out. We'll leave you today with the conclusion to Martin's story. Until next time, goodbye.
Next act is waiting in the wings. Big hellos, fancy clothes and shiny things. We get edged towards the door. Just grab my hand and don't look back at what's in store. I can tell you where